Before we continue, I see the hands were up, so I'm gonna assume that that was a confirmation that you can hear me. Thank you, students, for joining today's session, where we will be talking about the variable consequences of a civil marriage. And before I start, please let's remember the ground rules. The first one is please make sure that your mics are always muted and you only unmute yourself if you want to ask a question or if you have something to say. Before I continue with today's session, can just one or two of you just tell me, when we talk about the variable consequences of a civil marriage, do you know what you are talking about? Do you have any idea? Did you read your textbook? Just one or two of you, just tell me, when you say the variable consequences of a civil marriage, what are we talking about? Students? I'm not seeing any hands. Sibonu Kuhle, you can unmute yourself.
Okay, what I understand from variable consequences, these are the consequences that can be changed. So these are the consequences that the married couple can contract out of.
Okay, thank you so much for that. You are correct. These are the consequences that the spouses who enter into a civil marriage can actually change. Remember, last week we were talking about the invariable consequences of a civil marriage, which are the consequences that spouse cannot contract out of. So when spouses enter into a civil marriage, they need to decide if they want to enter into an in community of property marriage or an out of community of property marriage. Today we are going to talk about marriage in community of property. Marriage in community of property is a default system. That means that when spouses or when engaged parties sign the marriage register and they have not entered into any other contract, they have not entered into an antenuptial contract, their marriage will automatically be in community of property. So to enter into a marriage which is in community of property, you do not have to enter into any contract. The marriage becomes in community of property by default, by just signing the marriage certificate. Marriage in community of property, or the term community of property, is also known as universal community of property. It entails that spouses becomes co-owners of all the assets that they had before they entered into a marriage and all the assets that they acquire while they are married. It also includes the liabilities, the debts that spouses had when they before they entered into a marriage, and debts that they are going to accumulate or they are going to acquire while they are married. Although when you enter into a marriage and you just sign the marriage certificate, your marriage will be automatically in community of property. There are circumstances whereby in community of property will not be applicable. The first one is firstly, when parties enter into an antenuptial contract, which we'll talk about next week, and then when parties enter into what is called postnuptial contract. We are going to talk about, if we're not gonna cover it, if we won't have enough time to cover it next week, we're going to cover it that other week. But postnuptial contract is when the parties have are married in community of property, and thereafter they change their marriage contract from in community of property to out of community of property. And for them to do this, they need to bring a high court application. The magistrate courts, the regional courts do not have the powers to change marriage contract. It is a high court application and it is known as post-nuptial contract. The other circumstance where community of property does not apply is what is known as the lex domicile matrimony principle. This means that in terms of our laws, all South African women follow, not South African women, all women follow the laws of their husband's country if they get married in South Africa. So when you get married, there's two processes that are happening. There is the legal requirement to enter into a marriage, and there is the matrimonial property system that is going to regulate your marriage. So when you enter into a marriage, you need to follow the legal requirements that will lead to a valid, legally recognized marriage. But once this has happened, the parties themselves, they also need to make sure that they decide which matrimonial property system they want to regulate their marriage, whether it is community of property or out of community of property. But if you are a woman and you do not enter into any other form of contract in order to exclude community of property, and you get married, you are going to, the law will impose the laws of your husband's country. For example, a South African woman who gets married to a South African man, the laws of South Africa are going to apply. A South African woman who gets married to a Nigerian man, although the Nigerian man is residing in South Africa, and let's say they are residing in South Africa through a study permit or through a temporary permission that they can be in the country, they are going automatically, they are going to be subjected to the husband's country's laws. So, for example, in Nigeria, the default system is out of community of property. So that means that upon getting married and following all the legal requirements, if they don't enter into an antenuptial contract, the default marriage system will be automatically out of community of property, because the husband is not a resident of South Africa. But if the husband is a resident of South Africa, the marriage will be automatically in community of property. This is known as the lex domicile matrimony. Before I continue, does anybody have any question on this, especially the last principle that I've just spoken about? Do you understand how the lex matrimony principle, the lex domicile matrimony principle applies? Students, can I take your silence as you understand everything? Does anybody want to have any comment? Okay, let me ask this question. Can just one or two of you answer me? What is your view regarding this lex matrimony principle, whereby here is a South African, or here is two South African women and one who is married to a South African man? The marriage system is going to be automatically in community of property, but one who is married to a non-South African man, the marriage is going to be out of community of property. Although, let's say they are sisters, they are both residing in South Africa, and both their husbands are residing in South Africa. So what is your view about it? Do you think it's fair? Do you think those who get married to non-South African men should be subjected to different rules? What is your view about the lex domicile matrimony rule? Students, just one or two of you, let's discuss this principle. Anyone? Okay, Mukhadi, you can unmute yourself.
Thank you, and a very good morning to you.
Morning, Mukhadi.
Okay, I find it fair in that it's more like I come from the Lorodi family, and then let's just say there is a Motiba family. I cannot come from the Lorodi family and still want to change rules in the other family. So it's fair in that every nation has its own rules, so they should abide by it. So if they allow me coming from a different nation and then seeking the rules that I am coming with from my nation, it will cause disrupt, because if they allow it, then it means anyone can just change rules. It's fair. I find it fair.
Okay, thank you for that, Mukhadi. Mukhadi finds it fair. Personally, I don't find it fair because, firstly, it's only women who are subjected to this. If a South African man gets married to a Nigerian citizen, this rule does not apply to them. And then secondly, spouses who are in a same-sex relationship, this does not apply to them, because remember, it's only applicable if a woman gets married to a non-South African. So in same-sex relationship, it is men and men and women. So it does not matter which nationality or which country the spouses belong to, it does not apply to them. So if you look at it from the constitutional perspective, there is a bit of unconstitutionality on it, because only one group of people, which is the female, and at the present moment, it is a rule which came into being because of common law, and there is no justification why women should be subjected to this or should continue to be subjected to this, while other women who get married to South African men, or South African men who get married to non-citizen women, are not subjected to this rule. Okay, Mukibela, you can unmute yourself.
Good morning to you all and everybody who participated this morning.
Morning.
I've got an opinion that seems to agree with you that, to me, it is unfair because it discriminates against women. Especially, take for instance, for an example, a man who comes from Nigeria coming to South Africa to marry a South African woman. Most of the people they want here, they just want to come here in order that they should have the citizenship of South Africa. So again, this law favors this person that comes from outside. So a possibility of abuse, for me, is very, very clear that it can happen. Maybe this is one of the things that we experience problems here in South Africa, of men coming from outside getting married to South African women. Thank you.
Okay, thank you, Mukibele. Mulebukeng, I see your hands is up. Mulebukeng?
Yes, there's a student who seems just shared a question on the chat. He says he's having, I don't know whether it's a he or she, pardon me on that one. They say they have a technical network issue, so they're posing a question. On page 72, I don't know if you are there yet or...
Okay, you can ask, I'll open the page.
Okay. On page 72, on the text point B and C, the competent witness, can it be anyone? And also, can we get a simplified breakdown of the 2 points, prior written consent and written consent?
Okay, I'm going to discuss that. I think it's here. If you can see the document that I've just shared under the administration of the joint estate. So just hold on to that question, and when we get to administration of the joint estate, please remind me and ask me that question again. Molebogeng, did you hear me? Okay. Back to what we were talking about. Yes, so at the present moment, the lex domicile matrimony principle is still applicable, and it is very important, student, that you know about it, because an extremely high number of people, including students and some people in the legal fraternity, they automatically assume that if spouses don't have an antenuptial contract, the marriage is automatically in community of property, irrespective of which nationality the spouses belong to. It is very, very important to know, because many people, especially those who are undergoing divorce, they only get to find out, women who are undergoing divorce, they only get to find out during the process of divorce when they claim 50% of the joint estate, that no, in their marriage, the joint estate is not applicable due to the fact that their husband, when they got married. So with this principle, even if after getting married, the husband acquired a residentiality in South Africa, it says that at the time of entering into a marriage, if the husband is not a South African, this principle will be applicable irrespective of how many years the parties will remain married, and irrespective of the fact that the husband subsequently acquired citizenship in South Africa. I hope that is clear. Now we are going to talk about the content, or what does community of property entails. When we talk about the assets, we talk about anything that has monetary value, anything that one has a right over, a title or an interest in. And remember, things like smaller things like phones, fridges, immovable properties and non-immovable properties, both spouses have an undivided and an indivisible share over it. That means that if there's a table, you own 50% of the table, I own 50% of the table. But we know that things like, for example, a table, if the parties are undergoing a divorce and they need to share it, they cannot just cut it like in between. So although parties, or although spouses are co-owners of everything that they have, if it happens that the marriage ends through divorce and there is sharing of assets, the parties will just have to decide that, okay, I'm gonna take this asset and we are going to take this asset and we are going to share our assets in equal share. And then if they cannot agree, then all those assets needs to be sold and the parties needs to share money in equally. So they equally need to share the proceeds that they get from selling of the assets. So this is again is very important that you know, especially as a prospective legal practitioners, that although parties co-own all the assets, that doesn't mean that when they have to share, they physically need like to break them into two and all of that. Yeah. Okay. And then next, I want us to talk about separate assets which do not form part of COP. Here I wrote assets excluded in an antenuptial contract, assets excluded by a will or deed of donation. Okay. When let's say your parent they leave a will, they die and they've left a will. And then in a will, they don't know, their inheritance, they don't want the inheritance that they have left you to be shared by your spouse. They need to specifically state in a will that any inheritance acquired by my child or by the beneficiary must not form part of their marriage in community of property. This is also applicable if, let's say, your parents donate an asset, they donate a house to you, and they do not want your spouse to have a share in that house. In the donation document, they need to specifically state that this donation should not form part of the joint estate. If, let's say, there is a will, but a will does not have this clause, then the inheritance or the donation will automatically form part of the joint estate. Student, again, this is something that is very important that you need to be aware of. Merely having a will does not automatically mean your spouse will not have a share in whatever you're going to inherit. What is important is, does the will or does the deed of donation have a clause that specifically states that whatever is given to a spouse who is in a joint estate marriage, or who is in a community of property marriage, whatever they are given should not form part of their joint estate. If that clause is there, then that asset is protected from forming part of the community of property. If that clause is not there, then whatever asset is going to form part, because the will is silent. If your parent passes away and you inherit and they did not leave a will, whatever you're going to inherit is going to form part of the COP. So it is extremely important as future lawyers that you understand that if you want to protect your client's interest, you need to let them aware that if you are going to get married, or if your child or if any relative that you want to leave inheritance to, they are married and they are married in community of property, they have to make sure that they have a will, and not just have a will, there is that clause that specifically excludes whatever inheritance or whatever donation from forming part of the joint estate. Before I continue, can I get thumbs up that you understand? Your silence, I'm going to assume that you understand. Thank you, Mukhadi. Okay. The next one is assets which are subject to the fiduciary or the Userfruct. These again do not form part because of the nature of them. The next items which do not form part of community of property are the engagement gifts. For example, an engagement ring. And the rings, again, they become a part of your personal assets, and also benefits under the Friendly Societies Act, and non-patrimonial damages. Non-patrimonial damages refer to, the most common one is the damages or money that you get from the road accident fund. That is regarded as a personal asset, because most of the time it, or not most of the time, you receive those damages because of the injuries that you sustained. So we've just had, what is it? There was a court case recently whereby the issue was, if a spouse receives non-patrimonial damages before they get married, and then they get married in community of property and enter into the marriage with those non-patrimonial damages, do that damages form part of the joint estate? And the court held that yes, they do. So now the difference is non-patrimonial damages, in order for them not to form part of the joint estate of community of property, you must have received them while you are in an existing in community of property marriage. But if you receive them before you got married and then you enter into a marriage with those damages, they will automatically form part. So the section, which is section 18, subsection 1 of the Matrimonial Property Act, which excludes the non-patrimonial damages from forming part of the COP marriage, does not protect spouses who received these damages before they got married. It is only applicable to those who are already in an existing community of property marriage. Before I continue, can I get thumbs up to see that you understand, or does anybody have any question? Anybody have any question? Okay, believe you can unmute yourself. Believe, please unmute yourself.
Hello, good morning, ma'am.
Morning.
I just have a question here. Actually, it might be two questions. The first one is with regards to the fiduciaries and Userfruct. What is the difference between those two? And my next question is on the fruits. Like, for example, I'm in a marriage in community of property, and then I inherit something from, let's say, a relative who passed away. Let's say, for example, a car. Then, after inheriting that car, I sell it. Then, with the money that with the proceeds from that sale, I buy another car. Is that car gonna still fall out of community of property, or now it's gonna become in community of property? Those are my questions.
Can you repeat the second question?
The second question I'm saying is about the fruits. Like, for example, I inherit a certain asset from a deceased relative. Then I sell the asset and bought a replacement. Does the replacement automatically falls under in community of property?
Okay.
Under the joint estate, I mean.
Okay, thank you. Firstly, the first question, the difference between the two. A Userfruct is, for example, both of these two, they come into being through death, through a bequest that you get once somebody has passed away. We'll use a parent as an example. So in a Userfruct, for example, a parent can leave a property for you and say, you are going, let's say it's your father. Your father say, I am bequeathing you, I am leaving you this property on the condition that my wife, while is still alive, is going to have uninterrupted occupation of the house, meaning that you are going to be the beneficiary. You're going to inherit the house, but your mother will have the right to live in that house, and then maybe in the will your father has said the house should not be sold up until my wife has passed away. So your mother will have a right to live in that house until they pass away. So the reason why it is excluded from COP is because of the instruction, and that you inheriting that property, that house, it is subject to this Userfruct, meaning that another person having lifetime use of that property until they pass away. And then the fiduciary refers to, again, is a bequest, whereby, let's say your father leaves you a property, and then they say upon your death, this property should go to, let's say, either your younger brother or your first child and all that. So although you inherited that property, it came with the condition that don't sell it, and when you die, please transfer it to somebody else. So it is a gift that is given to you when death occurs, but it is subject to the rules or to the conditions, not the rules. It is subject to the conditions of the deceased. I try to simplify it. Do you understand?
Yes, ma'am. I do understand. So basically, the difference there is on ownership. Was like the way you explained it. In an usufruct, you are not inheriting the item. You are just having the right to use it, but you don't own it. Someone does own it.
Okay, now let me explain that. In a Userfruct, let's say it is me, I am giving you a house. You are going to be the owner of the house, but subject to the condition that our mother is going to live in that house and have uninterrupted occupation until she dies. So you are the owner, but your powers as an owner are restricted. So you will have uninterrupted and ownership, and you can do whatever you want only after our mother has passed away. To understand? So you are an owner, but there are conditions.
Okay, yeah, I get that.
Yeah, then the fiduciary is when I'm giving you the house and I say when you passes away or when you no longer want that house, give it to our younger sister. So there you are an owner again, but you are not free to do whatever. So even when you die and you leave a will and say, I leave this house which I received from Kathleen, I leave it to my younger son, then our sister can come and say, but remember Kathleen said upon your death, that house is supposed to come to me.
Okay.
Understand? Yeah, but this is more of a property law issue and not a family law one. Okay. And the second question was about the fruits. So if you inherit an asset which is excluded from community of property, and you do not want the fruits of that item which has been inherited to also benefit the COP spouse, you as the person who writes the will, you are known as the testator, you need to specifically state that I leave my house to my daughter, and the condition that this inheritance should not form part of their COP marriage together with its fruits. Because if, let's say, you leave them a house, then they sell it and then they take the proceeds of that house and then go and buy another house. So if you did not specifically state that the fruits should also not form part of COP, then the fruits will form part of COP. So the will must specifically state that anything that comes as a result of that asset that they inherited should not form part of the COP marriage.
Okay, ma'am, well understood. Thank you so much.
Okay, thank you. I just want to see, is there anybody else who still has a hand up? Okay, let's continue. Let's continue. Okay, we're talking about non-patrimonial damages. I just have a question on this. Again, the question is about the constitutionality of it. As we know that the reason why Section 18, subsection A, protects or excludes the non-patrimonial damages from forming part of the COP marriage is because they say, let's say you are in a car accident, you are the one who was injured, and then in your personal capacity. So those damages, that money is seen as your personal asset. So do you think it's fair that if you get buried while having these damages, let's say you had invested them, because in this case that I was talking about, what happened is the parties got married in year 2015, but before that in year 2011, the woman was involved in a road accident fund and suffered damages, and she was paid 800,000 rand. From that 800,000 rand, she took 550,000 rand, 550,000 rand, and invested it with a Standard Bank. And then it's not clear if they were still in a relationship or they met afterwards, but with the partner, they got married in the year 2015, and when she got married with this investment from Standard Bank, which was money from the road accident fund. The marriage did not succeed, and during the process of divorce, the husband claimed 50% of the money from the investment, and the lady argued that the lady was the respondent. It's a Supreme Court of Appeal judgment. The lady or the respondent or the wife argued that this money I received as a result of injuries that happened to me. And in terms of Section 18, subsection 8, it says that non-patrimonial damages are personal assets and should not form part of the joint estate. And because of this, our joint estate should exclude this money that I received from road accident fund. And the husband was the applicant argued otherwise, and his argument was, when we got married, we agreed that what is yours is mine and what is mine is yours. And this principle only applies to those who are already married. When you entered into this marriage, you knew that you had this investment, and you could have opted to marry out of community of property. By agreeing to marry in community of property, you are basically saying, I also have a share in that money that you have invested. So my question to you, student, is, do you think it's fair that when you are already in an existing marriage and you receive money from road accident fund, then that money from road accident fund is yours alone? Your spouse is not entitled to it. But if you received it before you got married, then you need to share it with your spouse. So just one or two of you, what is your view on this? Do you think spouses who receive money, road accident fund money before they get married, are being discriminated against? Because at the end of the day, the source of this money is from the same place. It's from non-patrimonial damages. Okay, what is your view on this judgment? Because it's a fairly recent judgment from the Road Accident Fund, from the Supreme Court of Appeal. Anybody, student, let's just have a quick discussion on this.
Hello, ma'am.
Hello, Philip.
Yeah, I think on this one, the judgment was fair. Because when we get into marriages and we agree that we are going to get married in community of property, we shouldn't look at how did you acquire the wealth or the assets that you have at the moment, at the particular moment. Was if it was going to be like that, then you would find out that maybe we would have to exclude a lot of things. But now I think if you know that you have got some kind of property that you inherited and you don't want it to form part of the joint estate, I think it makes sense for you to just say, okay, I don't want to get married in community of property. Let's just get married out of community. If you want to exclude it, it makes sense to say, if you acquire it during the marriage, then fine, it doesn't form part of the joint estate. But what you had before was everyone can still come and say, I got this through that, I got this through that, I got this through that. But if it's in community, at the point where you get married, you are coming together now, it doesn't matter what you have, we agree that we are going to share everything that we have. Then let it be like that. No one should say, because I got this through this means, then it doesn't have to form part of the joint estate. I think for me, it was a fair judgment.
Okay, thank you so much. Sibonu Kuhle. Sibonu
Good morning
Kuhle.
again.
Morning.
Can you hear me? Okay.
Yes, we can hear you.
So I think that the exclusion of non-patrimonial damages during the subsistence of the marriage is somewhat okay not in the context of road accident fund, but say this woman got her non-patrimonial damages from a delict case against her own husband. In a case like that, I think those damages should be excluded, because then all he would be doing is taking out of his pocket back into his own pocket. So I think in that case, it can get tricky to include non-patrimonial damages into the community of property.
Okay, thank you so much. Mukhadi? Mukhadi?
Thank you. So what I think is, if one has to exclude the fact that I got this money through accident fund, and then you find that the other still there are some things that he obtained outside the marriage, and you find that it kids and they have students at least through accident fund. The other partner might also say, I've worked hard towards this alone. So if it be that they exclude one, then should it rather be that everything that was obtained outside marriage should not be included, and then what should be included is what is done once the marriage commences. So I find it not fair that the money of road accident fund it not be included in the marriage.
Okay, thank you so much. I agree with you. I also personally think the judgment is fair, because when parties, or when lovers, or when prospective spouses make the decision to get married, one of the requirements, or one of the things that they need to do, is to get proper legal advice and make the decision as to whether they want to enter into an in community of property marriage or out of community of property marriage. So you cannot take rules or rights or privileges that apply to those who are already married and want them to be applicable to you, even for non-patrimonial damages, for anything that was acquired while you were still single or while you were still unmarried. So I do agree with you. And the next one, which does not form part, is, as somebody has said, damages as a result of personal injury inflicted by the other spouse. So if non-patrimonial damages are received due to the fault of the other spouse, they remain the other spouse's personal assets. And then costs in a matrimonial action and proceeds excluded by court in terms of prevention of organized crime, they are also excluded. And then attachment of separate assets. In the case of Duplessis versus Binary, they ruled that when it comes to attachment, let's say the parties are having financial problems and there's insolvency. In Duplessis versus Pinar, they said that exclusion of an asset from the joint estate does not protect the asset in the case of insolvency. So basically, all those assets which are automatically or which are excluded from forming part of your COP, let's say for example, an inheritance and a property that you have inherited, if a spouse, if the parties are having financial problems, or let's say if your spouse is having financial problems and they are being sequestrated, that asset will not be seen as a separate asset and therefore not form part of the insolvency. So although between you and your spouse those assets are protected, but if there is insolvency, then all those separate assets will now form part of the joint estate, but only if there is insolvency. Do we understand? Okay, your silence, I'm going to assume that you understand. Thank you. Believe?
Ma'am, I've got a question where you said patrimonial damages from or claimed from the other spouse do not form part of the joint estate.
Non-patrimonial.
Yeah, I
Okay.
just got a little bit curious with that one because, like, for example, let's say the couple fight or they were involved in a fight, then someone got injured, and then they then claimed damages from the other spouse. Then, if I say, for example, I claim damages from my wife and we are married in community, which means everything that she owns is part of the joint estate, and even her salary and my salary is just more like one and the same thing. Where is she gonna get the money to pay me those damages now?
Okay, from their own salary, because remember, practically, although when you are married in common of property and the two of you are working, you will have your own salary, he will have his own salary, and in an ideal marriage, both parties will bring in or hand over all their salaries and maybe have a joint account, or even if it's not joint account, just one account where they deposit all those monies. But we know that it does not happen that way. So the other one can be ordered that you will have to pay your spouse, let's say 50,000, and that 50,000 will have to come from their salaries and be given to the other one. So on the face of it, it's like the 50,000 that they are paying, 25,000 of it basically belongs to that other spouse. Understand? But so yeah, on the face of it, it's like I'm paying you 50,000, but in reality, I'm only paying you 25,000 from my 50% of this joint estate, because the other 25% by virtue of COP, it actually belongs to you. But once you have paid that 50,000, it belongs to that spouse alone, and it doesn't. It will not form part of the joint estate, so they can do whatever they want with it without having to justify themselves to you, or getting a consent to you on what they need to do with it.
Okay.
You understand? Okay. Thank you for that. Okay, and that was about the assets. Now we are going to talk about the liabilities, the debts. So debts that were incurred before marriage all becomes part of the joint estate. Unfortunately, here it also includes debts that you were not aware of. You can, let's say you meet your partner and he has this huge, or she has this huge student loan that you are not aware of. And then you enter into a marriage, then upon getting married, you realize that, this person is actually highly indebted. Unfortunately, you cannot argue that they should have informed me, or they misled me, because also as a spouse, you have a responsibility to make sure that you find out everything about your partner before getting married. So all debts that were incurred before getting married, they automatically form part of the joint estate. And then debts incurred before, during the subsistence of the marriage. Here they differ, because they're gonna differ as to whether are they contractual debts. Does the spouse who created the debt, did they have the capacity to bind the joint estate? And also they depend on whether they are delictual debts, and also on whether there are other debts. So for this one, you're gonna have to study from page 68, where okay, not page 60, from page 67, where it talks about liabilities, the antenuptial debts that were made before, and then from 68 it talks about debts which were incurred before, during the subsistence of the marriage, and then the contractual debts. What is the position on contractual debts? What is the position on delictual debts? And on page, what is it? And on page 69 to 70, it also talks about other debt. So if you need to understand everything about the contractual debt and all of that, even for your exam, please make sure that you read these pages. You'll get all your answers there. Does anybody have a question before I continue? Anyone? Okay. Now, these are debts that you are liable for during the existence of the marriage. Now, the position changes when a divorce occurs. Remember, all marriages are going to come to an end, either through divorce or either through death. I call it the double D, either divorce or death. When death occurs, and while you are still in a joint estate, the surviving spouse, if the deceased estate does not have enough money to actually be able to pay the outstanding debt, the surviving spouse now becomes liable for all those debts. Whether they knew about those debts, whether they gave consent for some of the debts to be made, it's a different story altogether. But the problem is, once death occurs, it becomes difficult to say, I did not know, I did not consent, because the rules of administration of a deceased estate will be applicable. Now, debts that are paid during the dissolution of a marriage through divorce, you need to differentiate between the contractual debts and the delictual and other debts. For contractual debts, the debts that were made before getting married and which are still owing at the time of the divorce can only be recovered from the original debtor. So while you are in an existing marriage, those debts are recovered from the two of you, but during divorce, the creditors need to only go to the original debtor. And then those debts which was incurred during the subsistence of the marriage can be claimed from the original debtor, and the other half can be claimed from the other spouse. In other words, this one is 50-50. And then delictual and other debts, this debt, the debt outstanding at the dissolution of marriage, can only be claimed from the original debtor. So when you study, please be very careful and pay attention, because you might get a question that says, okay, if the debts were made before the parties entered into a marriage and they are now undergoing a divorce, what is the position on that debt? If what is it? Something like that. So you need to be very careful. Like, as you can see from this note that I have done, I've tried to separate them so that you know that death before marriage, this is the position. Death incurred during the subsequence of the marriage, this is the position. And deaths that are outstanding at the dissolution of the marriage, this is the position. Understand? And at the dissolution of the marriage, we are only going to ask about the termination through a divorce. We will not ask about through death, because we know that through death, different rules apply altogether. Okay, before I continue, do you understand, students? I'm gonna take your silence as you understand, and as I've just said now, if you want to make your studies, to make things easy for yourself, as you are summarizing the notes, try to break them down. Because even when you're going to have an open book exam, if you have just drafted your own notes, it's going to make things extremely easy for you. And it's gonna increase your chances of getting good marks in the exam. Okay, now I want to talk about administration of the joint estate. Again, here, when you study in your textbook, you need to pay particular attention. For example, you need to know that the X, you need to know what are the transactions for which consent of both parties is required. You need to know the transaction for which the other spouse's consent is not required. These are from page 71 to 74. That is where the consent of the other spouse is required. If that consent is not obtained, it's going to make the transaction null and void. Ne? Again, let me say it's going to make the transaction null and void. On principle, but we know in reality, and especially for some of those who are married, or maybe you have heard from other people who are married, that you know what, I've just found out that my spouse actually went and took out this huge loan, and I never consented. How were they able to obtained such a huge consent? So there are certain transactions where a spouse must consent, but whether that is practiced in reality is a different story altogether. It is the responsibility of the creditors to ensure that the other spouse's consent is obtained. Sometimes they do obtain that consent, but the other spouse will use fraudulent means to make sure that that consent is obtained. Others will just be negligent and don't bother obtaining the consent of the other spouse. Others will make sure that they obtain the consent of the other spouse, and if the other spouse does not grant that or does not give that consent, then they are not going to approve. They're not going to approve whatever transaction that the spouse wants to enter into. So it is very important that you must know the transactions that a spouse must firstly consent to, and the other thing, you must know which transaction require written consent, which transaction just require verbal consent, and which transaction is actually unnecessary to obtain consent of. Okay. And now this is the consent. Ne? Then the second aspect that comes is the protection measures. The protection of third parties. If let's say you loan a friend or a family member who is in an in-community of property marriage, you are a third party, you need to know what protection is there for you. Let's say in the case whereby that spouse fraudulently obtained consent, or you entered into a transaction and their spouse is no longer paying, whether you can actually still recover your money even if the other spouse did not consent. So you need to know the protection that is afforded to third parties. You need to know the protection that is given between the spouses themselves if one goes and enters into a transaction that prejudices the other spouse. What protection measures are there for them? And in those protections, you need to know what are the statutory remedies, and you need to know what are the common law remedies. And these are from page 74 up until page 81. Again, students, if you want to make to understand this section very clear, when you write your notes, please break them down. Please break them down so that it's going to be easy for you to understand, and then during the exam it's going to be easy for you to just to quickly find the answer if if you come across a question relating to this. And the last on COP, capacity to litigate, you need to know spouses who are married in community of property, the capacity to litigate, when can they be sued together, when can they be sued separately, and when can they sue each other, because the spouses who are not married, who are married in community of property, cannot sue each other unless in circumstances like, for example, if one suffers non-patrimonial damages because of the act of their husband, or not of their spouse, either husband or wife. Now, having said that, Molebogeng, can we go back to that question that you asked?
Yes. The question, it's based on page 72 of the textbook.
72. Okay, let me go to page 72, point man.
Point B and C.
Okay, where it says prior written consent attested by two competent witnesses in respect of each transaction, and the other one is written consent attested by two competent witnesses in respect of each consent. Okay, what is the question?
The question now is, the competent witnesses, can it be anybody?
Okay, in terms of the law, they need to be, I think, from 16 years and above. But it can be anybody who is matured, who is of sound mind. So in most of the transaction, you will, especially with the financial institution, they will just get somebody who works with them to actually act as a witness. But spouses have a right to bring anybody who's offside mind, who is actually to give evidence in court should they be called upon. So it can just be anybody as long as they're offside mind, and preferably it should not be a minor child.
Okay.
Okay.
And then the last question was that you break down the 2 points, which is the prior written consent and the written consent.
Okay, just hold on. Okay, prior written consent, because if we look at, let's just say, the definition of the word prior, it means before. So it says the consent that you need, the prior consent that you need before entering into this transaction. So in other words, before you enter into this transaction, you must have had this prior consent. For example, alienating of an immovable property, that is like selling a property. So before you can put, let's say, your house on the market, and before you can talk to estate agent, you must have had a consent from from your spouse. But the written consent, I can maybe give an example by saying it is one that, let's say we go and get a loan, a mortgage loan, and then we have to sign there and there. Remember, to alienate or to sell an immovable property, you as a spouse, you can do the process on your own without the other spouse, as long as they have prior, or they have consented to it, and then I go ahead and complete the transaction on my own. But if we go and get the loan, the bank will say the two of you must be here, and then you need to sign at the same time. After signing, you sign, right? In the presence of us and then two competent witnesses. So that is just how I can explain it. Okay, Mlebogeng?
Yes, thank you. No, I think that was the only question. I don't know if Tsepiso is making a comment or it's a question.
Okay, no, it's fine. Student, we have now reached the end of our session. Thank you for joining, and thank you for participating. Next week, we are still going ahead. We are still continuing and discussing the variable consequences of a civil marriage, but we are going to talk about out of community of property, out of community of property, and the types of out of community of property. If you have any questions that you would like to ask us, or if you need any clarification, please feel free to send us. Please feel free to send us an email. Molebogeng, can you please write our email address on the chat so that they see our email address? The email address will be written on the chat, and you can send us an email. You can send us an email if you need any clarification. Again, student, can I please ask that at least once or twice in a week, please go to the my UNISA site, my Moodle site on Moodle, and check the announcement. We are aware that we have been having technical issues, and we do post an announcement there, but you are not receiving them on email. So the best thing that we can do for now is if each and every one of us take the responsibilities, and then at least, let's say, or not even twice, let's say 3 times in a week, let's say maybe on Monday, not Monday, let's say on Sunday, and then again on Monday or Tuesday, and then on Wednesday, and then again on Friday. Please check if there are no announcement that need your attention. If it's possible, you can even maybe just try and check twice a day, once in the morning and then later at night, just before you sleep, so that you make sure that you do not miss important information, because by posting announcement is the only way that we can give out information to you students, as we do not have your email addresses, and it is impossible for us to have your email addresses, because there is quite a huge number of students doing this module. So please, students, I am asking you, just make sure that you check the announcement, not only from us, also from our colleagues who also post important information for your attention. Yeah. Okay, thank you, students. And also, again, we have a YouTube channel where we upload all the recordings of these sessions. You can find the link of the YouTube channel in the Moodle, in the my Moodle site. Today's session is also recorded and is also going to be uploaded on our YouTube channel and also on the my Moodle site. So please, you can tell all your other fellow students who were unable to attend, students, that they can listen to the recordings there. Students, thank you so much, and we shall see each other next week. Thank you, and have a good day ahead. Goodbye.